The grand marble halls of the Supreme Court building echoed with hurried footsteps as journalists and legal observers rushed to secure seats for what promised to be a historic oral argument. At stake was House Resolution 7890, a voting rights protection bill that had divided Congress along party lines for months. The bill, which aimed to strengthen protections for minority voters and modernize election systems, had faced fierce opposition from conservative groups, claiming it would federalize elections and weaken state sovereignty. Justice Ketanji Brown Jackson, the first black woman to sit on the Supreme Court, had been watching the case develop with particular interest. Appointed by President Biden in 2022, Jackson had established herself as a meticulous jurist with a formidable intellect. Her background as a public defender gave her unique insight into how laws affected real people, not just legal theories. Though typically composed and methodical, those who knew her recognized the slight furrow in her brow that appeared whenever voting rights cases came before the court, a sign of her deep concern for the fundamental right to vote. Today would be different, though. The House Democrats had chosen an unexpected champion to defend their legislation, Representative Jasmine Crockett from Texas. At 42, Crockett was relatively new to Congress, but had already made waves with her fiery speeches and legal acumen. Before entering politics, she had built a reputation as a civil rights attorney in Texas, fighting against voter suppression and defending protesters during the 2020 racial justice movements. Her legal credentials were impressive, graduating with honors from the University of Houston Law Center, but many questioned whether she had the experience to argue before the highest court in the land. Conservative media had been particularly harsh. One prominent newspaper had declared that Congresswoman Crockett was in over her head, suggesting the Democrats should have chosen an experienced Supreme Court litigator instead of a freshman representative looking to boost her profile. Even some liberal outlets expressed concern, noting that while her passion was undeniable, the Supreme Court required a technical precision that usually came with years of appellate experience. But House Democratic leadership had made their decision, believing Crockett's combination of legal knowledge and personal experience with voting rights issues made her the perfect advocate. The House Democratic leader had told reporters she understood what was at stake better than anyone, and warned not to let her short time in Congress fool anyone, describing her as one of the sharpest legal minds he had ever encountered. The case had drawn intense public interest, not just because of its implications for future elections, but because it represented a direct challenge to the court's 2013 decision that had weakened the Voting Rights Act. Conservative justices had signaled skepticism about congressional authority to impose new voting rights requirements on states, while the court's liberal wing, including Jackson, had indicated they saw clear constitutional authority for federal action. As Crockett entered the courtroom that morning, she carried not just legal briefs, but the weight of history. She had grown up hearing her grandparents' stories of poll taxes and literacy tests in East Texas. She had represented clients who had waited hours in line to vote in minority neighborhoods while polling places in whiter areas had no lines at all. This was not just another case for her, it was personal. Justice Jackson understood this personally as well. Though she rarely spoke about it publicly, Jackson had her own family stories of relatives in Florida and Georgia fighting for the right to vote. As a judge, she was bound by legal precedent and constitutional interpretation, but she also carried an acute awareness of how abstract legal theories translated into real impacts on communities of color. The atmosphere in the courtroom was charged with tension as Chief Justice John Roberts opened the session. The conservative wing of the court sat stone-faced, their previous rulings on voting rights suggesting they viewed this law with skepticism. On the other side, the liberal justices appeared more receptive, though bound by their duty to test the legal arguments rigorously. As Representative Crockett approached the podium, a hush fell over the gallery. No one knew what to expect, but everyone understood the stakes could not be higher. The future of voting rights in America hung in the balance, and the dynamic between Justice Jackson and Representative Crockett was about to take center stage in ways nobody could have anticipated. Congresswoman Crockett began, her voice steady despite the gravity of the moment. She stated she stood before the court to defend the Voting Rights Advancement Act, which reaffirmed the nation's commitment to ensuring that every eligible American could exercise their fundamental right to vote without unnecessary barriers or discrimination. She had barely completed her opening statement when Justice Thomas leaned forward, his deep voice cutting through the chamber. He asked where exactly she found congressional power to override state voting procedures as extensively as this legislation does, noting the Constitution gives states the primary authority to regulate elections. It was a tough opening question designed to put her on the defensive immediately. Many seasoned advocates would have stumbled, but Crockett did not miss a beat. She responded directly, citing the article of the Constitution that explicitly grants Congress the authority to make or alter state election regulations. She additionally pointed to the 14th and 15th Amendments, which provide Congress with enforcement power to prevent racial discrimination in voting. She reminded the court that its own precedents had confirmed the broad scope of this authority. Thomas nodded slightly, but did not appear fully satisfied. Before he could follow up, Justice Barrett jumped in, questioning whether the court should be concerned about federal overreach into areas traditionally managed by states, touching on a core conservative legal principle. Crockett took a breath before responding. She acknowledged the court's concern for federalism, but stated that the constitutional system has always recognized that protecting fundamental rights sometimes requires federal intervention. She argued the historical record before Congress demonstrated persistent discrimination that state-level protections had failed to remedy, as Crockett cited specific evidence from congressional hearings. Justice Alito interrupted, his tone sharp. He questioned why the court should allow Congress to impose burdensome new requirements on states based on historical discrimination rather than current conditions. It was a direct reference to the court's reasoning in a previous, landmark case which had struck down part of the Voting Rights Act as outdated. This was the moment many observers were waiting for. Would Crockett challenge the court's controversial precedent directly? She responded with respect, but firmly, stating the record before Congress included extensive evidence of ongoing discrimination. She detailed that in the past decade alone, they had documented over 1,200 polling place closures in minority communities, purges of voter rolls that disproportionately affected non-white voters, and new identification requirements that federal courts had found to have discriminatory intent. As she spoke, Crockett pulled out a map showing the concentration of polling place closures since 2013, highlighting how they clustered in areas with growing minority populations. It was a visual representation of the data that seemed to catch several justices by surprise. Justice Kavanaugh, who had been silently observing, now entered the fray. He asked, even assuming these disparities exist, could they not be explained by neutral factors like resource constraints or population changes rather than discriminatory intent? Crockett was ready. She stated that if these changes were truly based on neutral factors, they would expect to see similar impacts across different communities. But the data showed otherwise. She provided a specific example from a county in Texas, detailing how areas that were predominantly white had one polling place for every 4,500 residents, while in neighboring areas that were predominantly black and Latino, it was one polling place for every 23,000 residents. The specificity of her answer appeared to give Kavanaugh pause. He made a note on the pad before him, a sign that her point had registered. Justice Kagan, who had been waiting patiently, finally entered the conversation, offering Crockett a momentary reprieve from the conservative justice's questioning. She asked Crockett to elaborate on why she believed current state-level protections were insufficient, noting several states had argued their own voting rights acts provide adequate protection. Crockett nodded appreciatively at the question. She explained that while some states had indeed enacted their own protections, this created a patchwork system where a citizen's voting rights depended on where they lived. Moreover, she argued that state courts are often constrained by elected judges who face political pressure when ruling on voting cases. She continued presenting data showing how voting protections varied dramatically by state, creating what she called two tiers of democracy. As she spoke, Justice Jackson leaned forward, closely following Crockett's argument. The real tension began to build when Chief Justice Roberts, who had authored the court's previous decision, finally spoke up. He stated that the court had emphasized that the Constitution is not violated by disparate impacts alone, but requires proof of discriminatory intent, yet much of her legislation appeared to rely on statistical disparities. He asked how she reconciled that with the court's precedent. It was a fundamental challenge to the legislation's approach, touching on the core legal dispute between conservative and progressive understandings of discrimination. The courtroom tensed, waiting for Crockett's response. She addressed him directly, stating the legislation recognizes the court's distinction, but also acknowledges the reality that discriminatory intent is often disguised. She explained that a specific section of the bill provides a framework for distinguishing between disparities resulting from legitimate policy choices and those suggesting underlying discrimination, requiring a multi-factor analysis rather than relying on statistics alone. Roberts appeared genuinely interested in this answer, making several notes. It was clear that Crockett had studied his opinions carefully and crafted her response to address his specific concerns. Just as the atmosphere seemed to be calming slightly, Justice Alito launched what many would later call his gotcha question, a complex multi-part challenge designed to confuse and trap the advocate. He questioned how she squared her position with decisions that established Congress must show a pattern of constitutional violations before overriding state sovereignty, and specifically how she could justify the Act's results-based test given the holding that the Constitution only prohibits intentional discrimination. The question combined multiple complex precedents, constitutional provisions, and legal standards, the kind of question that had flustered even the most experienced Supreme Court advocates. The conservative justices exchanged glances while several liberal justices frowned at what seemed like an intentional effort to overwhelm Crockett. The chamber fell silent. This was the moment that would either validate or destroy Crockett's credibility before the court. Justice Jackson watched intently, her expression unreadable, but her attention completely focused on the Congresswoman. Crockett paused, took a slow sip of water, and then looked directly at Justice Alito. What came next would change the entire dynamic of the argument and set the stage for an unexpected moment of judicial recognition that nobody in the courtroom would soon forget. Justice Alito, Crockett began, her voice clear and confident. She appreciated the complexity of his question and stated she would address each component systematically. She placed her notes aside, signaling she would not need them for this critical response. First, regarding the cases he cited, she stated those established a test for legislation enacted under one section of the 14th Amendment, but this legislation was primarily grounded in the 15th Amendment, which specifically targets racial discrimination in voting. Alito started to interrupt, but Crockett continued, her pace measured but unstoppable. She stated that if she may finish, this court has historically recognized that Congress has broader enforcement authority under the 15th Amendment. She cited a previous case where the court acknowledged that the Voting Rights Act's preclearance requirement was previously upheld as valid 15th Amendment legislation despite imposing significant burdens on states. Alito's eyebrows rose slightly. She had cited his own opinion back to him. As for the case about discriminatory intent, Crockett continued, she agreed it established that constitutional violations require discriminatory intent. However, she argued, Congress's enforcement power under both the 14th and 15th Amendments allows it to prohibit practices that have discriminatory results in order to prevent constitutional violations, even if those practices might not themselves violate the Constitution. She was building momentum, her legal analysis growing more precise with each sentence. The entire courtroom seemed to be holding its breath. She stated this principle was articulated in Justice Scalia's unanimous opinion in another case, which held that preventative measures may be appropriate when there is a documented history of discrimination. She emphasized that the legislative record for this bill included over 20,000 pages of testimony and evidence documenting both intentional discrimination and practices with discriminatory results that enable future constitutional violations. Justice Jackson's expression changed almost imperceptibly, a slight widening of the eyes, a look that legal observers in the room would later describe as profound respect. But Crockett was not finished. She reached into her briefcase and pulled out a bound document that nobody had expected. Furthermore, Justice Alito, she said, she would like to direct the court's attention to a largely forgotten precedent that speaks directly to his question, an 1892 case. At this, several of the justices looked surprised. It was an obscure case rarely cited in modern voting rights litigation. She explained that in that case, this court recognized that case-by-case litigation would be insufficient to address systematic voting discrimination. While the court at that time regrettably declined to provide a remedy, she noted that Justice Holmes had explicitly acknowledged that federal legislative action would be the appropriate response to systemic voting discrimination. She handed copies of the relevant excerpts to the court clerk for distribution to the justices. As the pages circulated, Justice Jackson leaned forward, an undeniable look of admiration crossing her face. Crockett continued, stating the historical context of this old case was particularly relevant here. It was decided amid widespread disenfranchisement of black voters across the South, similar to the coordinated efforts they had documented in their congressional findings. Justice Holmes recognized that judicial remedies alone would be insufficient, effectively inviting legislative action precisely like this bill. Justice Alito, clearly not expecting this historical excavation, glanced down at the document now before him. So to directly answer his multi-part question, Crockett stated, yes, their legislation meets the standards set forth in the cases he mentioned, because they had established a clear pattern of violations. Yes, a results-based test is an appropriate measure under Congress's 15th Amendment enforcement authority, despite the intent case. And yes, there is direct Supreme Court precedent recognizing Congress's unique role in addressing systemic voting discrimination when judicial remedies prove inadequate. The silence in the courtroom was deafening. Crockett had not only answered Alito's complex question, but had connected it to an obscure precedent that reframed the entire legal debate. Several of the conservative justices were now intently reviewing the excerpts, their expressions suggesting they had not anticipated this line of argument. Justice Jackson broke the silence, her voice measured but with an unmistakable note of appreciation. She acknowledged that the citation to the old case was interesting and asked Crockett to elaborate on how that precedent, a product of a very different era, should inform the court's analysis today. It was a friendly question, but also a substantively important one, inviting Crockett to develop her most innovative argument further. Crockett thanked Justice Jackson and explained that the old case represented what might be called a negative precedent, a case where the court acknowledged a fundamental problem but concluded it lacked the tools to address it. She quoted directly from the opinion, noting the justice had written that relief from a great political wrong must be given by the people of a state or by the legislative and political department of the government of the United States. Crockett paused, letting the quote sink in. She stated this was not just historical curiosity. It represented the court's recognition of the limits of case-by-case adjudication in addressing systemic voting discrimination and an explicit acknowledgement that legislative solutions are not just permissible but necessary. She argued that the Voting Rights Advancement Act was precisely the type of legislative remedy the old justice had envisioned, one that creates systematic protections rather than forcing voters to challenge each new restriction individually after the damage is already done. Justice Jackson nodded, her expression reflecting deep engagement with the argument. Other justices were now flipping through the old decision, some appearing to reassess their understanding of the court's historical approach to voting rights. Chief Justice Roberts, always attentive to historical context, joined the conversation. He asked how they should reconcile the old case with more recent precedents, given it was decided well before modern jurisprudence. It was a fair question and potentially devastating to her argument if she could not bridge the 130-year gap between the cases. Crockett responded confidently, stating she believed the two cases were actually complementary, not contradictory. She explained that in the recent case, the court held that the coverage formula could not be based on decades-old data and historical practices that may no longer reflect current conditions. Their legislation directly responded to that concern by creating a dynamic coverage formula based on current violations, not historical patterns from the 1960s. She displayed a chart showing how the new formula would work, highlighting its responsiveness to contemporary conditions. She concluded that the wisdom of the old case, that legislative remedies are necessary for systemic problems, remains valid, while the requirement for current evidence from the recent case is satisfied by their new approach. In essence, they had combined the institutional insight of the past with the temporal requirements of the present. The conceptual elegance of this synthesis appeared to register with several justices. Even Justice Thomas, typically the court's most skeptical member on federal voting legislation, seemed to be considering the argument with genuine interest. Justice Sotomayor, sensing an opportunity to build on Crockett's momentum, posed her own question about federalism concerns. Crockett explained the legislation actually enhances federalism by preserving state autonomy for states that protect voting rights while providing federal oversight only where necessary. She detailed that states can avoid federal preclearance entirely by simply maintaining clean records. No violations, no oversight. This creates what scholars call cooperative federalism, where federal intervention occurs only when states fail to fulfill their constitutional obligations. As she elaborated on this federalism-friendly framework, Justice Kavanaugh, who had clerked for a longtime federalism champion, appeared particularly interested. But the true climax came when Justice Alito, seemingly determined to regain control of the argument, posed what he clearly intended as a knockout question. He suggested her entire argument rested on the premise that state legislators are acting with discriminatory intent when they pass these voting laws, and he questioned whether it was extraordinarily inappropriate for Congress to essentially accuse state officials of racism without definitive proof in each case. It was a provocative question, one designed to force Crockett into either backing down or making an inflammatory claim about state legislators' motives. The courtroom tensed, recognizing this as a pivotal moment. Justice Jackson straightened in her seat, her attention fully focused on how Crockett would navigate this potential trap. Crockett took a deep breath, her expression serious but not confrontational. She stated their legislation does not require a blanket accusation of racist intent against any state legislature. Instead, it creates an evidence-based process for identifying laws that disproportionately burden minority voters, regardless of the subjective intent behind them. She paused, then added that she would also like to respectfully address the underlying premise of his question. She reminded him that this court has repeatedly recognized that discrimination in voting can occur without express racial animus. She cited a recent majority opinion that Justice Alito had joined parts of, which acknowledged that legislators may be acting with partisan intent rather than racial animus, yet still produce racially discriminatory results when race and political affiliation are highly correlated. It was a masterful pivot, acknowledging Alito's concern while subtly reminding him of his own jurisprudence that contradicted his implied position. She stated their legislation recognizes this reality. It does not label anyone a racist. It simply acknowledges what this court has already recognized, that voting discrimination can occur through complex mechanisms that do not require explicit racial hostility. The bill establishes neutral evidence-based criteria for identifying problematic laws, providing states full opportunity to justify any disparate impacts. The answer was measured, substantive, and diffused the emotional charge Alito had attempted to inject. Justice Jackson's expression transformed into one of unmistakable admiration, a look of professional respect that transcended ideological divisions. Then came the moment that would be replayed on news broadcasts for weeks. Justice Jackson leaned forward, removed her glasses, and addressed Crockett directly. She said, "Representative Crockett, your analysis of the interplay between the old case and our modern voting rights jurisprudence is genuinely illuminating." She stated she had studied voting rights law for decades and did not believe she had ever heard that particular connection articulated so effectively. She thanked Crockett for bringing this historical through line to the court's attention. The statement from a Supreme Court justice to an advocate during oral argument was extraordinary in its directness and appreciation. The other justices appeared momentarily frozen, surprised by the unusual departure from the court's typically reserved questioning. Even the court's conservative members seemed to register the significance of the moment. Justice Barrett nodded slightly in acknowledgement of the intellectual heft of the argument. Chief Justice Roberts, though not necessarily convinced by Crockett's position, displayed the respect of one legal mind recognizing the capabilities of another. Justice Alito, his earlier skepticism now tempered, posed a more measured follow-up question about specific provisions of the legislation, a clear sign that he now viewed Crockett as a formidable legal mind worthy of serious engagement rather than rhetorical traps. As the argument continued, the dynamic had fundamentally changed. What began as what many expected to be a one-sided legal mismatch had transformed into an intellectual tour de force, with Representative Crockett not just holding her own against the nation's top jurists, but advancing novel legal theories that appeared to be reshaping the court's thinking in real time. The remaining questions from justices across the ideological spectrum reflected this new reality. They were substantive inquiries about implementation details, transition provisions, and judicial review mechanisms, rather than fundamental challenges to the legislation's constitutionality. By the time the Chief Justice announced the case was submitted, the atmosphere in the courtroom had transformed. Legal observers exchanged glances of amazement. Journalists were already furiously typing on their phones, and Justice Jackson, as she gathered her papers to leave the bench, gave Representative Crockett a final, unmistakable nod of respect that would become the defining image of this historic Supreme Court showdown. The heavy wooden doors of the Supreme Court had barely closed behind Representative Jasmine Crockett when her phone began buzzing incessantly with notifications. By the time she reached the bottom of the marble steps outside, the scene that greeted her was unprecedented for a congressional representative after an oral argument. Dozens of reporters had gathered, cameras flashing and microphones extended. They asked for comments on Justice Jackson's remarkable statement, how she discovered the obscure precedent, and if she thought she had changed the court's approach to voting rights. Crockett, still processing what had transpired inside, paused briefly. She stated that today was not about her. It was about the fundamental right to vote that belongs to every American, regardless of race, wealth, or zip code. She said she was grateful the court gave this issue the serious consideration it deserves. As she made her way through the crowd, a legal intern who had been inside the courtroom approached with tears in her eyes. The young woman, a first-year law student, said what Crockett did in there was something she had never seen before, and that it gave her a whole new vision of what is possible. Crockett clasped the young woman's hand and told her to remember this feeling, stating there will be people who tell you that you do not belong in those rooms, but they are wrong. Meanwhile, inside the court's private conference room, the justices had gathered for their initial discussion of the case. While these deliberations are strictly confidential, sources close to several justices later revealed the extraordinary impact of Crockett's argument. One clerk confided that the historical connection she made genuinely changed the conversation. Justice Jackson was not just being polite with that comment. Several justices who had seemed firmly opposed to the legislation before the argument were now wrestling with the historical throughline Crockett had identified. Justice Jackson herself, known for her meticulous attention to historical context, reportedly expanded on her courtroom comments during the conference. She allegedly told her colleagues that regardless of how they ultimately rule on this case, they should acknowledge the remarkable scholarship Representative Crockett brought to this argument, stating the old precedent creates a historical framework that none of their prior voting rights cases had fully considered. Even justices ideologically opposed to the legislation were reportedly impressed by the technical quality of Crockett's advocacy. One conservative justice allegedly commented that it was a masterclass in Supreme Court advocacy, noting she did not dodge difficult questions or resort to emotional appeals but met each challenge with substantive legal analysis. Back in Washington, the political impact was immediate and far-reaching. Footage of Justice Jackson's unprecedented compliment played on every major news network. Legal analysts who had questioned the decision to have Crockett argue the case were now openly admitting their error. A prominent constitutional law professor admitted on television that he had been skeptical but was happy to be proven wrong, calling what Representative Crockett accomplished extraordinary. The House Democratic leader called a press conference within hours, stating that today, Representative Crockett reminded everyone why diversity in Congress matters. He said she brought perspectives and insights to the Supreme Court that might otherwise have been overlooked, and that this was not just a victory for their legislation, but a victory for representation. The impact extended beyond Washington. In law schools across the country, professors adjusted their syllabi to include discussion of the old precedent and its newly articulated connection to modern voting rights jurisprudence. A leading law review announced a special issue examining the historical lineage Crockett had traced from Reconstruction-era cases through the Modern Voting Rights Act. On social media, the moment erupted with hashtags related to the argument and the visible respect between the two women. A viral tweet from a law student captured the sentiment, writing that watching Justice Jackson acknowledge the Congresswoman's brilliance was like seeing the future of American law unfold in real time, stating this is what it looks like when the doors finally open wide enough for exceptional minds that were previously excluded. Perhaps the most significant immediate impact came from state legislatures across the country. In several states where voting restrictions had been pending, legislative leaders suddenly announced delays for further study. Political analysts noted that the prospect of federal legislation that might actually survive Supreme Court review had changed the calculus for state-level restrictions. An elections law expert noted that even if the court ultimately strikes down parts of the legislation, Representative Crockett's argument has created a roadmap for what might survive review, and that alone has shifted the landscape significantly. 3 days after the argument, an unexpected development further cemented the historical significance of the exchange. The Library of Congress announced the acquisition of Crockett's personal research notes and drafts leading up to the argument, recognizing their exceptional historical and legal significance in the ongoing development of voting rights jurisprudence. For Justice Jackson, the aftermath brought both praise and scrutiny. Her unprecedented public acknowledgement of Crockett's legal acumen was celebrated by many as a refreshing moment of intellectual honesty transcending ideological divisions. Others, particularly those opposed to the voting rights legislation, criticized it as a departure from judicial impartiality. Jackson addressed these concerns indirectly in a speech at a law school 2 weeks later without mentioning the argument specifically. She spoke about the importance of intellectual honesty on the bench, stating that as justices, they have an obligation not just to test arguments rigorously, but to acknowledge when advocates bring truly novel insights to their attention. She said the advancement of law depends on this kind of intellectual exchange, and when they recognize exceptional advocacy, they strengthen the legal system itself. For Crockett, the aftermath was transformative. Overnight, she had gone from a promising freshman representative to a national figure in both political and legal circles. Law firms extended partnership offers. Law schools invited her to give commencement addresses. The Congressional Black Caucus unanimously elected her to chair their voting rights task force. Yet Crockett remained focused on the substance of the case rather than her newfound prominence. In her first major interview after the argument, she emphasized the legislation itself rather than her performance. She stated that what matters is not whether she impressed the justices or made legal history, but whether Americans in every community have equal access to the ballot box, saying that is the only victory that counts. The long-term impact on voting rights jurisprudence would take months to fully materialize. When the court finally issued its ruling 4 months later, the outcome reflected the extraordinary impact of Crockett's argument. In a surprising 6-3 decision, the court upheld the core provisions of the Voting Rights Advancement Act with Chief Justice Roberts writing for the majority. While the ruling did not accept all of Crockett's arguments, it explicitly acknowledged the historical connection she had drawn between the old case and modern voting rights challenges. The majority opinion cited the previously obscure precedent 7 times, effectively incorporating Crockett's historical analysis into the court's voting rights jurisprudence. The opinion stated that when Congress acts to prevent systemic voting discrimination, it operates not just within its 15th Amendment enforcement authority, but within a tradition of legislative remedies this court has recognized for over a century, directly referencing Crockett's argument. Justice Jackson's elaborating on the historical throughline Crockett had identified and praising the legislation's evidence-based approach to addressing contemporary voting discrimination while respecting federalism principles. Legal scholars noted that the decision represented a significant evolution in the court's approach to voting rights, one that might not have occurred without Crockett's innovative legal argument and Justice Jackson's willingness to acknowledge its merit. One professor observed that what everyone witnessed was not just a legal argument, but a genuine moment of intellectual breakthrough, where Representative Crockett's argument created a bridge between historical precedent and contemporary challenges that reshaped the court's understanding of its own jurisprudence, and Justice Jackson's recognition of that breakthrough showed the best of what judicial engagement can look like. The impact extended beyond the specific legislation at issue. Within a year, 3 major voting rights cases had cited the court's new precedent, creating what legal observers called a new doctrine, the principle that case-by-case litigation alone cannot address systemic voting discrimination, requiring comprehensive legislative remedies when evidence shows patterns of discriminatory impact. For ordinary Americans, particularly those in communities with histories of voter suppression, the effects were concrete and immediate. States previously covered by preclearance requirements once again had to submit voting changes for federal review. Polling place closures in minority neighborhoods were reversed. Early voting opportunities expanded. Voter ID requirements included broader alternative identification options. One community in rural Georgia, which had previously seen its only polling place closed, forcing residents to travel 25 miles to vote, held a celebration when their polling place was restored under the new law. They named their community center after Crockett in recognition of her role in restoring their voting access. Perhaps the most lasting legacy came in legal education. Law schools across the country developed new courses examining the historical evolution of voting rights jurisprudence with the Crockett argument as a central case study in effective Supreme Court advocacy. A prestigious institute created an annual lecture highlighting breakthrough moments in constitutional argument, naming it after the two women. The inaugural lecture was delivered jointly by Representative Crockett and Justice Jackson, a rare public appearance by a sitting justice alongside a political figure, justified by the educational significance of their historic exchange. Introducing the pair, Justice Sotomayor captured the significance of what had transpired in the courtroom that day. She stated they witnessed something extraordinary, a moment when intellectual brilliance transcended ideological divisions, when historical insight created new possibilities for constitutional interpretation, and when two remarkable black women showed everyone what the future of American law can look like when every voice has the opportunity to be heard at the highest levels. As Representative Crockett approached the podium to begin her portion of the lecture, she paused and looked out at the audience filled with law students, many from backgrounds historically underrepresented in the legal profession. She stated that what happened in the Supreme Court that day was not just about her or Justice Jackson. It was about every person who has ever been told they do not belong in the rooms where power resides. It was about every voice that has been silenced in the democratic process. And most of all, it was about the ongoing project of building an America where the right to vote, the most fundamental right in any democracy, truly belongs to all of us. The lecture concluded with a standing ovation that lasted nearly 5 minutes. A fitting tribute to a Supreme Court moment that had indeed left not just the court, but the entire nation frozen in recognition of an unexpected alliance between two brilliant legal minds committed to the protection of fundamental rights. If you found this story of a historic moment where intellectual brilliance and dedication to justice changed the course of American law inspiring, we have so many more deep dives into the figures shaping our world. Don't forget to like this video and subscribe to our channel so you won't miss our latest political analysis and compelling stories about today's most influential leaders. Let us know in the comments what other political stories you would like us to cover next. We will be back soon with more compelling content that goes beyond the headlines to reveal the true dynamics shaping American politics and justice.